202.12 Preliminary Conference. A party may request a PC at any time after service of process. The only exception to this is in sub L, when there's a terminally ill party. That person can request the PC at any time after commencement of the action. So after a summons a complaint or summons with notice is filed, a terminally ill party can file the physician's affidavit and request a PC. The request for PC shall state the following things. There's 4 of them. Title, index, names, address, phone numbers of all attorneys, and nature of action. If there's no assignment to a judge, the party shall file the request for judicial intervention, RJI, together with the request for PC. The request shall be served on all other parties and filed with the clerk for transmittal to assigned judge. The court shall order a PC in any action upon compliance with the requirements of this subdivision. So then we have a soft 45-day rule. So the court shall notify all parties of the scheduled conference date, which shall not be more than 45 days from the date the RJI is filed, unless the court orders otherwise, and a form of a stipulation and order prescribed by the fucking chief administrator shall be made available, which the parties may sign, agreeing to a timetable to complete disclosure within 12 months for a regular case and 15 months for a complex case. If they all sign the form shall be so ordered by the court, and unless the court orders otherwise, the conference shall be canceled. However, if they do not sign and return the form by the conference date, so before the conference date, then the court shall hold the conference and the party shall appear at it. Except where a party appears pro se, so no lawyer, a lawyer who is thoroughly familiar with the action and authorized to act on behalf of the party shall appear at such conference. Where a case is reasonably likely to include electronic discovery, counsel shall, prior to the preliminary conference, confer with the other lawyer with regard to any anticipated electronic discovery issues. Further, counsel for all parties who appear at the conference must be sufficiently versed in matters relating to their client's technological systems to competently discuss all issues relating to electronic discovery. Counsel may bring a client representative or an outside expert to assist in such e-discovery discussions. Okay, so the next thing here is going to talk a little bit about something called ESI, electronically stored information. So pretty much electronically stored information, you would think that that would be like easy to discover, but apparently it's not. Apparently it's extremely burdensome and expensive to obtain electronic discovery. So just keep that in mind as I'm reading the next section. A non-exhaustive list of considerations for determining whether a case is reasonably likely to include electronic discovery is, and then there is a list of 5. 1, does it exist? 2, does anyone want to rely on it? 3, are there less costly or burdensome alternatives? 4, are the cost and burden of preserving and producing ESI proportionate to the amount in controversy? And 5, what is the likelihood that discovery of the ESI will aid in the resolution of the dispute? So let's just review that quick. Basically, 1, does it exist? 2, do you need it to prove or defend the case? 3, is there any other way we can get discovery without resorting to ESI? 4, is the case worth enough money to make somebody pay for ESI? And 5, what's the likelihood that even discovering this information will resolve the case? C, the matters to be considered at the preliminary conference shall include, and then it goes into a long list. Again, just read it. Simplification of legal and factual issues, timetable for disclosure, electronic discovery issues. You know, there's a list of 10 items there. Just read them. Addition of other necessary parties. So this is talking about joinder, and in joinder, there's 2 kinds of joinder. There's misjoinder and non-joinder. So misjoinder is when you accidentally sue somebody that really had nothing to do with the case, or you include them on the lawsuit in some way, and then that's misjoined or they shouldn't have been there, the court can just drop that party. The other method is a little bit more important, and that's called non-joinder. So if there's a party that's a necessary party, that party should be joined in the action if complete relief is to be accorded. And if that party is unable to be joined in the action, then the court can actually dismiss the action without prejudice if that party is not included in the action. So that's what number 4 is talking about, addition of other necessary parties. 5, settlement. 6, removal to a lower court where appropriate. And CPLR 325 is kind of a lengthy thing, so maybe I'll go over that at some point before we go into CPLR. And 7, any other matters the court deems relevant. So at the conclusion of the conference, the court has 2 options. They can make a written order, which is the preliminary conference order, or everything, directions of the court and the stipulations of counsel can be recorded by a court reporter. Excuse me. Where the latter procedure, so where the court reporter procedure is used, the parties equally share the cost of the transcript unless the court says otherwise. The transcript shall have the force and effect of a court order. The transcript shall be filed by the plaintiff with the clerk of the court, so with the county clerk, because we're in Supreme and County Court. E, the granting or continuation of a special preference shall be conditional upon full compliance by the party that requested the preference with the foregoing order or transcript. When a note of issue and certificate of readiness are filed in an action where this section applies, the filing party, in addition to all the other rules, shall file with the note of issue an affirmation or affidavit with proof of service showing specific compliance with the preliminary conference order or transcript. Listen, if you worked in civil, you know nobody does this, but it's here. So let's just make sure we know it. It says that when a party has a preference, a special preference, the continuation or granting of the preference, which means you get to jump the line on trial cases, and they file a note of the preference, the party with the preference files the note of issue. In addition to filing the certificate of readiness and everything else they're supposed to file, they also have to file an affirmation or an affidavit with proof of service on all the appearing parties showing specific compliance with the preliminary conference order or transcript. F, in the court's discretion, failure to comply or the making of unnecessary or frivolous motions by a party shall result in the imposition upon such party of costs or other sanctions. G, a party may move to advance the date of a preliminary conference upon a showing of special circumstances. H, motions that are made after the PC has been scheduled may be denied unless there's good cause why the relief is warranted before the PC is held. I, no action or proceeding shall be deemed ready for trial unless there's compliance with the provisions of this section and any order issued pursuant thereto. J, the court may at any time order such conferences as it deems helpful or necessary in any matter before the court. K, the provisions of this section shall apply to preliminary conferences in med-mals and matrimonial property tax assessment in New York City only to the extent that these provisions are not inconsistent with 202.16, 56, and 60 respectively. So basically what that says is that these preliminary conference rules apply to matrimonials, medical malpractice actions, and tax review assessments. But if there's a provision in one of those rules that are specifically written for those type of actions, and it's inconsistent with something in this section, that specific section would apply in lieu of this. L. I went over this briefly before. The provisions of this section shall apply where a request for PC in an action involving a terminally ill party governed by CPLR 3407 only to the extent that it's not inconsistent with 3407. In an action governed by 3407, the request for PC may be filed at any time after commencement of the action and shall be accompanied by the physician's affidavit required by that provision. So generally, you have to actually serve the other side before you can request a preliminary conference. But in the action filed by a terminally ill party pursuant to 3407, who's alleging that I'm terminally ill because of the negligence or tort of the defendant, something he did or failed to do, I can request it immediately as I file the action. So as soon as I commence the action, I can file a request for a preliminary conference if I file physician's affidavit that I'm terminally ill and I'm claiming it's the defendant's fault. But other than that, I have to wait until I've actually served the defendant to request a preliminary conference.